Assalamualaikum warahmatullahi wabarakatuh. Welcome to our channel. Today my friend Amirah Husna and I Hilmiah will be presenting about our last assignment for Law of Tort subject, which is case review. We will assign the case of KAVITHA anak perempuan KRISHNAN and another against Kerajaan Malaysia. Happy hearing! So, before we proceed to the whole review, I would like to give an overview. In this video, we will tell you guys about first, the parties involved, which is the plaintiffs and the defendant. Next, the detail of the case, which we will include the name of the court, what suit case, the judge in charge, and the judgment. Third, the facts of the case, from the material facts to the legal issue of this case. Fourth, the judgment, the ratio decidendi, and the holding. Last but not least, our comment and analysis, which is from our view. As to in the contents, the parties involved in this case is Kerajaan Malaysia, who is the defendant of the first case and the appellant for this case. However, Kerajaan Malaysia is not a primary tortfeasor. Next, KAVITHA anak perempuan KRISHNAN, one of the two plaintiffs of the first case and also the respondent of the appeal case. Nonetheless, please be reminded that the public officer who transfers the blood to the plaintiffs is not the parties involved in this suit, since he is not being sued in this case. This is a civil suit case which was held at the High Court of Kuala Lumpur and judged by Judge Yohwi Siam on the 7th January of 2013. Next, the facts of the case. Initially about the blood transfusion. As a result of a blood transfusion performed by the defendant's public officer, the plaintiffs were diagnosed as HIV positive. So the plaintiff sued the defendant 36 months after the public official gave the blood transfusion. However, the plaintiff's claims were declared void since the pleadings failed to identify the public officer who was allegedly liable for medical negligence or default. As a result, the court granted the defendant's request to attack on the Enclosure 7, the plaintiff's claim under 018 R19 of the Rules of Court 2012, as there is no valid cause of action against the defendant and was an abuse of court procedure. Plus, the defendant also argued that the plaintiff should file a complaint within 36 months of the alleged offence, as required by Section 2A of the Public Authorities Protection Act 1948. The legal issue in this case is whether the government could be sued for the disease the plaintiffs diagnosed under medical negligence. Therefore, the judge in making the judgment followed this as the ratio decidendi. First, Section 5 of the Government Proceedings Act 1956. Subject to this act, the government shall be liable for any wrongful act done or any neglect or default committed by any public officer in the same manner and to the same extent as the laws of Malaysia, in which a principal, being a private person, is liable for any wrongful act done or any neglect or default committed by his agent and for the purposes of this section, and without prejudice to the generality thereof. Any public officer acting or purporting in good faith to be acting in pursuance of a duty imposed by law shall be deemed to be the agent of and to be acting under the instructions of the government. Second, Section 6 in bracket 1 of the Government Proceedings Act, no precedent shall lie against the government by virtue of Section 5 in respect of any act, neglect or default of any public officer, unless proceedings for damages in respect of such as neglect or default would have lain against such officer personally. Third, as in the case of Kerajaan Malaysia and others against Lay Kitty and others, and government of the state of Sabah against Syarikat Raspan, the judge said, therefore, on a proper construction of Section 5 and 6 of Act 359, and in any claim in tort against the government, the officer of the government who was responsible for the alleged tortious act must be made a party and his liability must be established before the government can be made liable vicariously as principal. It will be insufficient to merely identify the officer as a party because liability by evidence needed to be established. It is only upon a successful claim against the officer personally can a claim be laid against the government. Next, in Section 2A of the Public Authorities Protection Act, where after the coming into force of this act, any suit, action, prosecution or other proceeding is commenced in the Federation against any person for any act done in pursuance or execution or intended execution of any written law or of any public duty or authority or in respect of any alleged neglect or default in the execution of any such written law, duty or authority, the following provision shall have effect. A. The suit, action, prosecution or proceeding shall not lie or be instituted unless it is commenced within 36 months next after the act, neglect or default complaint of or in the case of a continuance of injury or damage within 36 months next after the ceasing thereof. And last but not least, in Ronald Vidal against Hamza Hasham Samar and others, where the Court of Appeal held in respect of that section of the English Act, which is in parametria with our Section 2A, that the language of the section was reasonably plain and it was manifest that the continuance of the injury or damage meant the continuance of the act which caused the damage. Time would therefore begin to run for the purposes of the ordinance from the time the act was caused, not from the time when the injury or damage ceased, or in the case of a continuing injury or damages when the act causing the injury or damage ceased. Hence, the appeal allowed defendant would only be vicariously liable and the defendant could not be sued. Moreover, the facts of this case fell within the first limb of Section 2A of the Public Authority Protection Act 1948.
Okay, so as has been explained about the facts and the judgment of the case earlier, now we're moving on to our analysis and comments on this case. Okay, so based on the decision that has been made, the judge here is on the side of the plaintiff by stating that the claim made by the plaintiff is not time-barred under the second limb of Section 2 Clause A of Public Authorities Protection Act 1948, or also known as PAPA. Okay, so in our opinion, we did not support the decision made by the court judge. So for this presentation, we have provided two reasons to not support the decision made. Okay, so firstly, the facts of this case were supposed to fall under the first limb of Section 2 Clause A of PAPA, but the plaintiff used the second limb that caused the case to be governed under that limb. So this is because of the limb that was used by the plaintiff, they were not liable for being time-barred. So if we refer back to the first limb of the Section 2 Clause A, it has been stated that the suit, action, prosecution or proceedings shall not lie or be instituted unless it is commenced within 36 months next after the act, neglect or default complained of. So which means that the claim can be made within 36 months after the act has been done. While in the second limb, it was stated that in the case of a continuous of injury or damage within the 36 months after the ceasing thereof, which means that the claim for the case of a continuous injury is within the 36 months after the end of the injury. So we can see that both limbs bring out different time limitation. So if this case is to happen under the first limb, the plaintiff claim will be time-barred as the claim was made on the 6th July 2012 and the plaintiff has suffered HIV from the blood transfusion on 5 April 2001, and so the claim will be unvalid. But since the case was governed under the second limb, the plaintiff claim would not be time-barred as the HIV that the plaintiff suffered is not ceasing since it is known as a continuous injury. Okay, so based on our analysis, it would be unfair as the case was supposed to be time-barred, which leads to our second reason, where the injury, which is HIV that the plaintiff suffered, has no end. Okay, so since the judge has decided for the case to fall under the second limb, this shows that the case is a case of a continuous injury. So even so, we disagree with the decision to be made under the second limb, which leads the plaintiff's injury to be categorized as a continuous injury, like has been mentioned in the second limb. Okay, so to make this clear, HIV infection does bring a lifelong injury, but this disease will always be in the carrier's body for the rest of their life and will not kiss. So as stated by the World Health Government in 2021, there is no cure for HIV infection. However, with increasing access to effective HIV prevention, diagnosis, treatment and care, including for opportunistic infection, HIV infection has become a manageable chronic health condition, enabling people living with HIV to lead long and healthy lives. So this proved that HIV infection could not kiss from the body, but could only be controlled with the prescribed medicines, so that the people who have HIV could live normally like other people, even with the disease in their body. So from here, it can be seen that it is unreasonable to make a claim using the second limb of Section 2 Clause A on a never-ending disease. Okay, so to strengthen our argument, we could refer to the case of Pendaftar Hak Milik Negeri Selangor and Cases Development Senjiran Berhad and others, and another appeal 2020. So we go through to the facts of the case first. Okay, so the defendants argued that the change of name took place on the 28th September 2011. Okay, so the writ of summons was only filed on 20 April 2015. So hence, the plaintiff's action was clearly caught by the limitation, as more than 36 months had passed from the date the cause of action arose till the date of the filing of the suit. Okay, so this was against the Section 2 Clause A of Public Authorities Protection Act 1948. Okay, so it was held in the case that the plaintiff is not caught by the limitation. Okay, so the judge stated that the plaintiff's injury or damage is ongoing and has yet to end, as has been submitted by the learned counsel for the plaintiff. Okay, so in this case, both of the limbs are being considered and mentioned in making the decision of the case, but they did not specify what limb they used in making the decision. So, and plus, in any event, if we do look into what limb it fell into, this case will still not be turned back. If this case was to fall on the first limb, the case is still within the 36 months, and it is found in the judgment that the plaintiff became aware of the name change in May 2012. So, it was found that the cause of action actually began only in May 2012. So, and if this case was to fall on the second limb, it is acknowledged that the said land is still registered in the names of the first and the second defendants. This means that the said land has not been returned to the plaintiff, so the plaintiff's damage is still ongoing and has not ended. So, referring back to our cases, the case could not use both of the limbs, as both of the limbs will bring different results of whether the plaintiff claim is time back or not. So by using this case, we can prove that both of the limbs are important to determine which limb does it fall. Okay, so as this case has already been decided by the judge, thus this case can be used as an argument to support an issue during a court trial. So we predict that in the future cases, there will be a flood of claims on any lifelong injury that suffered by the parties. So flood of claims here means that there will be a loss of people who will make the same claim based on a particular decision made. So when this happens, there will be a loss of people who suffer from a non-curable disease like HIV who made a claim under the second limb of Section 2 Clause A of PAPA. So as has been mentioned earlier, even though the people who have the disease can still live a normal life, there will be some of them who would file suit by using the decision of this case. Okay, so we're nearing the end of our presentation. So in conclusion, in the end of this case law, the judge itself stated about the arguability of whether the facts of the case fall under the first limb or second limb of Section 2 Clause A of PAPA. Okay, so throughout this presentation, we firmly disagree with the judgment of the case, as the facts of the case were supposed to fall under the first limb of Section 2 Clause A, and that the HIV disease suffered by the plaintiff has no end. So not only this case was governed on the second limb, this disease also will not kiss forever, which will make the limitation of 36 months not start to count as based on the second limb. So thus, as the decision that has been made by the judge on the plaintiff's claim was not time barred, there will be a high possibility that there will be loss of claims from people who suffered incurable disease by using the judgment of this case in the future. Okay, so however, at the end, it is up to the court who rules on the matter to decide whether the party is liable or not. So this is considering that the attorneys lack the authority to persuade courts to make the decision in case. So therefore, we hope that this case could be reissued and be brought to the higher courts so that there will be no confusion happening in the future cases, whether the case should be governed under the first name or remain governed on the second name. Okay, so I guess that is all from us. Thank you and Assalamualaikum warahmatullahi wabarakatuh.